Good afternoon. Thank you all for joining us today. My name is Jesse Berg, and along with my colleague Tony Fricano from the Minneapolis office of Lathrop GPM, we are going to be presenting for the next hour and a half or so on some brand new regulations under the Stark Law, anti-kickback statute, and civil monetary penalties law. We have a significant rulemaking to talk to you about this afternoon, and as a result of that, we have a lot of different topics to cover. We'll do our best to get to all of these things, but we want to be sure that you understand that we are more than happy to take any questions that you might have. If you do have questions, please use the chat function on the webinar to submit those, and we'll get to as many of them as we can at the end of the presentation. We're certainly happy to follow up with you after the webinar if we don't get a chance to get to your question. I also want to let you know that this webinar is going to be recorded and it will be available on our website starting on Monday, along with a copy of these slides. You will be receiving a follow-up email directing you to that page on our website. And we're also going to be making available an updated handbook that our law firm has related to complying with the Stark Law in particular, and going through many of the exceptions and changes that we'll be talking about today. The other thing I'll mention is that CLE credit for this event has been sought in Missouri, Minnesota, and Illinois, and follow-up information will be sent upon approval. So with that, I'm going to just jump right in and get started. You can see the agenda here of what we're hoping to cover. But before we get into the substance, I just want to spend a minute or two kind of level setting for folks. A big chunk of what we're talking about today are changes to the Stark Law and the anti-kickback statute that have been made in order to try and help healthcare providers participate more robustly in value-based reimbursement. The trend in using value-based reimbursement in healthcare has been happening and growing for the past few years. It really got started with the passage of the Affordable Care Act in 2010, and some of the models under the Affordable Care Act that have been created, intending to help providers be incentivized financially to deliver quality, reduce costs without hurting quality, and better outcomes for patients. The challenge, of course, is that some of the fundamental regulatory principles that providers need to deal with, in particular the Stark Law and anti-kickback statute, have been significant roadblocks to collaborating between or among providers to achieve good value-based outcomes. CMS and OIG, to their credit, have been working on this for a number of years. That work came to a head at the end of October 2019 when proposed regulations were issued. The normal process for rulemaking at the federal level is that proposed regulations come out, and then there's a period of time for folks to submit comments responding to those proposed regulations. And that's what happened here. The agencies received hundreds of comments from all sectors of the industry related to the proposed regulations. They took those comments back and they started working on final regulations. And those were expected to come out at the beginning of 2020. Of course, COVID hit the country in February and March of 2020, and that, of course, resulted in agencies like CMS and HHS really needing to turn their attention elsewhere. So these rules seem to be put on hold. And in August of 2020, CMS and HHS issued guidance basically saying that they were going to need to delay finalizing these rules until the summer of 2021. Then, lo and behold, everyone got a surprise right around Thanksgiving, November 20th. We saw the release of a pre-publication version of these final regulations. Then finally, on December 2nd, the regulations were published in the Federal Register, and we have citations on the slide to all of those rulemakings for your reference. In general, the regulations do quite a bit to change healthcare, to change the way the Stark Law and anti-kickback statute work. This slide illustrates at a high level some of those trends. We're not going to talk about all of them. You'll see as we go forward that a number of these will come up. Just mention a few here, though, as we get started. One in particular is that some of the traditional protections that we see in Stark law exceptions and anti-kickback statute safe harbors have been changed. So concepts around fair market value payment, for instance, that has been modified under these new value-based exceptions and safe harbors out of a recognition that the old definitions didn't really work very well for value-based collaborations. CMS and OIG have also tried to take some steps to help providers collaborate between each other outside of the value-based world. So there is a growing recognition of the importance of having strong electronic health records technology and cybersecurity technology. And these final regulations make some changes that are intended to allow providers to collaborate more than they could in the past. And along the same lines, changes intended to help providers incentivize patients to get care from a value-based arrangement, largely driven from the fact that a goal of value-based reimbursement is to keep patients within the same care delivery model. So jumping into the value-based changes to start with, we basically have a set of 3 new exceptions and 3 new safe harbors. The exceptions apply under the Stark law, the safe harbors apply under the anti-kickback statute. One of the good things from the proposed rule, comparing the proposed rule to the final rule, is that the agencies really have recognized that some of the things they've proposed were pretty complex, pretty challenging, and they've done a lot to try and simplify things. Now, as we move forward with this, you'll probably just think to yourself, well, it still seems pretty complex, and that is definitely the case. Don't want to sugarcoat it. The regulations are complex, but they do reflect an effort to try and simplify them to the extent that the agencies felt comfortable. One of the ways they've done that, in particular with respect to the value-based arrangements, is by using similar definitions whenever they could, which is helpful for folks. Another thing that they've done, which is pretty helpful, is make clear that financial relationships that meet these exceptions and safe harbors can be protected, whether we're talking about Medicare and Medicaid patients or whether we're talking about commercial patients. That's sometimes been a challenge in the past. In general, the more risk that parties are willing to take on, the broader the scope of protection under these value-based exceptions. And the converse is the less amount of financial risk you're willing to assume, the more rigorous the requirements of the exceptions will be. So the exceptions and safe harbors really start with a series of definitions. In the abstract, these might not make that much sense, but when you sit down and you start working through the exceptions and safe harbors, you'll see that these definitions, they really build on top of each other. And fortunately, they're aligned between Stark and between anti-kickback in almost all respects, which is very helpful. So for example, one of the things that the exceptions and safe harbors do is they talk about the definition of a value-based activity. And you can see the definition of that concept at the top of the slide. And the value-based activity essentially reflects the steps that parties need to take to try and achieve a value-based purpose. So again, realizing that in the abstract, that sounds kind of vague. When you dig into the exceptions, you'll see a little bit about what I mean though. So for instance, under the Stark law exception for full financial risk arrangements, we'll talk about in a second, you'll see, for instance, that one of the elements of that exception is that the payments protected under the exception have to be for value-based activities undertaken on behalf of patients within the targeted patient population. So for example, if we were thinking about a value-based arrangement that is focused on managing the care of patients who've had joint replacements, one of the things a value-based arrangement might do is require post-discharge meetings involving personnel from the hospital and the physician intending to collaborate around best practices for the patient's discharge. So in a situation like that, a value-based activity might be something like attending meetings related to discharge planning, which are reasonably designed to achieve the value-based purposes. And I'll talk about those in a second. Value-based purposes essentially mean things like improving quality, reducing costs without impairing quality, for example. As a trade-off on some of the program integrity safeguards we normally think about in Stark and anti-kickback, things like fair market value and the volume of value of referrals, those, for the most part, have been taken out of the value-based exceptions and safe harbors. But we are seeing different types of program integrity protection that the regulators want to see. So for instance, your value-based enterprise, which is the name of the collaboration between parties working together to try and achieve a value-based purpose. One of the things that the value-based enterprise needs to have is an accountable body, essentially, which is basically like almost like a board of directors or an individual responsible for oversight in terms of financial oversight and operational oversight of the value-based program. And as we move forward, one of the things we'll talk about under some of these exceptions is the obligation to track and monitor whether the parties are really achieving their value-based purposes, and if they're not, that they need to terminate the arrangement. And it would be this accountable body who's tasked with that responsibility, for example. More principles that really are baked in to all of these exceptions and safe harbors that you'll see here. I'm not going to go through all of them. I mentioned the value-based purposes. This is essentially what CMS and OIG are trying to incent under the exceptions and safe harbors. The target patient population. So that's basically the name CMS and OIG are using to define the group of patients who are being managed under a value-based arrangement. And as another trade-off, again, taking the place of things like fair market value or compensation that takes into account the volume or value of referrals, what CMS and OIG are saying instead of those things is that providers participating in a value-based arrangement, they need to select their targeted patient population based on legitimate criteria. So if you, for example, were selecting patients solely because you thought that it might be able to reduce your costs, OIG and CMS would disagree that is consistent with the purpose of these exceptions. Another trade-off that you might notice is under the Stark law, for example, there's long-standing concept of compensation needing to be set in advance. That requirement has been removed from most of these exceptions under the Stark law, but in its place, you do need to have your methodology for selecting your targeted patient population be set in advance. So it's changes like that that are really taking the place of historic fraud and abuse concerns. Stark and anti-kickback take a different approach in terms of who can participate and be protected by the exceptions and by the safe harbors. The proposed rule for Stark suggested that Stark would exclude a variety of parties from being able to qualify from the exceptions. The Stark law, it changed its mind though in the final rule. Stark does not exclude any parties from eligibility under the Stark law exceptions as long as they meet the requirements. Anti-kickback statute safe harbors though take a different approach. And that really reflects another fundamental difference between Stark and between anti-kickback that the regulators point out a number of times. And that's basically that they view the anti-kickback statute essentially as a backstop to arrangements here. The consensus from CMS and OIG when you go through these regulations is essentially that you can have arrangements that qualify for a Stark law exception, but OIG still feels that those arrangements may in some circumstances pose risk under the anti-kickback statute. So that is the reason why the anti-kickback statute safe harbors tend to be more restrictive in general than the Stark law exceptions for these value-based arrangements. And this is one example. There's a host of entities you can see at the bottom of the slide here who cannot qualify for the safe harbors. Now, that doesn't mean they can't participate in a value-based arrangement, but it means if you are participating as a durable medical equipment company or a compounding pharmacy, for instance, you need to rely on a different safe harbor or a different anti-kickback statute analysis to protect remuneration under the value-based arrangement. This does get a bit complex because if you start reading those terms and you work with a large organization, you may think to yourself, well, we do some of those things. For instance, we might be a physician group that operates a laboratory, or we might be a hospital system that has a durable medical equipment company. So does that mean we're not eligible to participate? And the answer to that question is that OIG wants organizations to apply what they describe as a core function test. So the hospital and the physician group, in my example, they need to make a decision about whether laboratory or DME is predominant in terms of their line of business or whether it's something less than that. So depending on the kinds of things your organization does, this might be an area where it poses some complexity. Certain categories of entities, though, are really highlighted by OIG as problematic under these value-based exception. Physician-owned distributors, for example, it doesn't sound like the OIG really believes there's much room for pods in these arrangements. The Stark Law exceptions and the kickback safe harbors, there are some key concepts that tend to repeat themselves. And as I go forward, you'll notice I'm not going to go over these over and over, mainly because we certainly don't have time for that, but largely because there is commonality on a lot of these principles. So just mention a few of them. One, I mentioned fair market value. That's not relevant anymore under these value-based exceptions. The concept of taking into account referrals, it's not relevant under the value-based arrangement itself, but what CMS and OIG do not want you to do is have a swapping arrangement. So basically what they're saying is if you have a value-based arrangement that qualifies for one of these exceptions and safe harbors, you can't set it up in a way where you're trying to induce business outside of that value-based arrangement. So if we're talking about a nursing facility and a physician group collaborating around mental health care, for example, the physician group can't require the nursing facilities to send patients that have nothing to do with that value-based arrangement to the physician group. OIG and CMS are guarding against that. Another common trend from both Stark and anti-kickback is that these exceptions and safe harbors are prospective only. One of the comments that came in during this rulemaking was whether parties could use the new exceptions and safe harbors to protect things that they've already been doing, things that have happened in the past. And the answer to that is no. This is only applying looking forward as far as the things that you're doing. The exceptions and safe harbors only apply to compensation arrangements. So you can't use these to protect returns and investment from an entity, ownership interests in an entity, for example. We're only talking about compensation arrangements. Anti-kickback statute, a number of other common trends between them, some of which I've talked about already. I'll just mention a couple more. So the Stark Law exceptions protect monetary and non-monetary remuneration under all three of the exceptions. So that means, cash payments are protected, and the same, so are, equipment donations, technology donations, staffing, for example. Anti-kickback takes a little bit different of approach, and you can basically protect monetary remuneration only under 2 of the 3 safe harbors under the anti-kickback statute. Another difference is that one of the anti-kickback statutes safe harbors requires participants to make a financial contribution of 15%, which is something that OIG has done in past rulemakings. And that's not something that you see under the Stark Law at all. So the first exception in safe harbor is our broadest exception in safe harbor, and this basically protects full financial risk. Basically what OIG, what CMS are saying is that parties who are willing to assume on a prospective basis financial risk for the cost of all patient care can qualify for this exception and for this safe harbor. The exception and the safe harbor do build in a bit of lead time. So you can sign up your arrangement and you have up to a year to actually assume the risk, whether you're talking about the kickback statute or you're talking about the Stark Law exception. This is an improvement from the proposed rule when the neither option took that approach. The volume or value concept I mentioned a second ago, you can see that here it exists under both exception and the safe harbor, essentially saying you can't require business to come in from outside the value-based arrangement. That doesn't work. the civil monetary penalties law starts to pop up in these exceptions and these safe harbors, and you can see that here. And this again is where we're basically saying, in place of things like fair market value requirements, what we see here is the element that you cannot induce participants to reduce or limit medically necessary services under a qualifying value-based arrangement. So basically, the government is saying, we don't want you to reduce costs by preventing patients from getting the care that they need if it's medically necessary. Now, one of the big questions under the exception and safe harbor is, what do you mean by full financial risk? And during the rulemaking, commenters wrote in and they tried to get CMS and OIG to scale that back a little bit. For example, it was proposed, could we reduce the level of financial risk you have to assume to be 75% instead of 100%? The answer to that question is no. It needs to be 100%. Stark and Kickback take a slightly different approach. Stark says you need to be at the full financial risk for the term of the arrangement for a specified period of time, but it lets the parties essentially decide how long that's going to be. So you need to work with the payer in making that decision. And a Kickback statute safe harbor says you need to have a term of at least 1 year. Now, one thing to know is that when you say full financial risk, that doesn't necessarily mean full financial risk for everything that every person in the targeted patient population needs. What you can do is you can have an arrangement that only treats a certain condition for the targeted patient population, but you basically would have to cover the costs of all of the care within that population. So if we're talking about diabetes, a value-based arrangement intended to achieve better quality, reduce costs with respect to diabetes care, what that means is that the participants need to be at full financial risk for those patients, the diabetes patients. The Kickback statute and the Stark law have additional requirements, as you might expect. I've listed a few of them here. One of the interesting things is Stark doesn't require a written arrangement, a written agreement under this exception. The anti-kickback statute does. The anti-kickback statute requires the accountable body I mentioned a minute ago to really be in charge of having a quality assurance program. And so essentially that is a program that's intended to guard against underutilization for patients within the arrangement and also to monitor quality of care provided to patients within the arrangement. So that's under the anti-kickback statute safe harbor. It doesn't exist under the Stark law. The anti-kickback statute safe harbor has another requirement, which is basically saying you can't bill separately providers participating in one of these full financial risk arrangements for any of the services. And that's because you're assuming the risk for the entire cost during the term of the arrangement. If that exception seems like it's a bit much in terms of the level of financial risk at issue, OIG and CMS have kind of a middle ground exception. And the second exception in safe harbor is about assuming meaningful downside or substantial financial risk for the patient population. And this slide here goes through some of the requirements that are relevant for the parties. And basically, the levels of financial risk, I'll get to in a second, that's on the next slide. They differ between Stark and between anti-kickback statute. And for the Stark law, one of the things to remember is because of the way the Stark law works, it's definition driven. It talks about physicians making referrals for designated health services to an entity, which is technical. You need to consult each of those terms to find out whether Stark applies to an arrangement. That's different than anti-kickback statute, which is much broader. Stark law actually means that the physician or the physician organization needs to be assuming the financial risk, the substantial financial risk under this exception. And we'll talk about that in just a second. Another program integrity safeguard that OIG and CMS are using under this exception in safe harbor, and you see this across all three, is the requirement of needing to have records maintained that document your compliance with all of the elements for a 6-year period. The idea is that there may be occasions where the regulatory agencies want to find out what parties are doing to comply, how they're monitoring and tracking, for example, quality assurance, outcome measurement going forward. And that is a safeguard that we don't see under current exceptions and safe harbors. So I mentioned the level of financial risk at issue under this exception, and you can see how this works here. Kickback safe harbor really has two components. Value-based enterprise itself has to be at substantial downside financial risk, and there are three options for doing that. That's an improvement from the proposed rule, where there were 4 options which were more complex and more burdensome. The final rule has 3 options, and you can see a high-level summary of what those look like here on the upper left corner of the slide. And then the value-based enterprise, the participants in the value-based enterprise, they need to meaningfully share in that downside financial risk. So there's 3 ways for the enterprise itself to share in financial risk. Basically being at risk for 30% of shared losses is the first option. The second option is an episode of care-based model, essentially where losses and savings are calculated by comparing current expenditures for all of the services at issue for the targeted patient population against a benchmark measurement to track costs. And then the third option is involving the value-based enterprise basically getting a per patient per month payment that's intended to result in savings over a period of time for the participants in the arrangement. And then once you have that done in terms of the kickback statute, the participating parties need to meaningfully share in that risk. And again, there's 2 ways to do that. One of the improvements between the proposed rule and the final rule was to reduce the level of risk that the participating entities need to accept from 8% down to 5%. This is different than the Stark law, where we really only have one level of risk sharing that we need to deal with here. And that's, again, because of the way Stark works with its definition-driven applicability. And essentially what they're saying is that our physicians or the physician organization needs to be responsible to pay no less than 10% of the value of remuneration under the program. A variety of other elements that are relevant under this exception and safe harbor as well, and have a few of them listed here. One of the challenging ones under the kickback statute safe harbor is the remuneration that you get. You need to use it predominantly to engage in value-based activities. So that starts to raise the question of how parties are tracking the remuneration that they're getting and tying it into the achieving value-based activities in pursuit of a value-based purpose. And basically what they're saying is you have to tie it to one of 3 value-based purposes that the parties are trying to achieve. So again, things like improving quality of care, or at least maintaining care without reducing costs would be another option. Stark law isn't quite as rigorous in terms of tying the remuneration that you get to the value-based activities. The methodology for doing it needs to be set in advance, but it's not at the same level as the kickback statute under that Stark exception. Another difference is that anti-kickback gives you a little bit of time to build up to assuming the meaningful financial risk, but not quite as much as the full financial risk exception, where you had 1 year to reach that assumption of risk. Under anti-kickback, the participating parties need to assume risk within 6 months. Stark takes a different approach. There is no ramp-up period under the Stark law. You need to be assuming the risk right away. The third set of exceptions and safe harbors is kind of intended to help parties who don't want to assume any financial risk at all still have more flexibility than they do currently under Stark and under anti-kickback to participate in these arrangements. And the trade-off, if you're not going to be assuming any financial risk, is that you have more complexity under the exception and under the safe harbor. Now, OIG, when it created these regulations, they actually say, look, we recognize this is complicated and it might prove a bit burdensome to people, but we're doing this because, again, we're a backstop for arrangements that comply with the Stark Law, but we think still might pose risks under the anti-kickback statute. So that's their thinking as far as why the arrangement is more complex in terms of the safe harbor versus the exception. So how is it complex? Well, one of the ways it's more complex is that there's this ongoing monitoring requirement that you need to have in place here. And basically what that's saying is that the parties need to be tracking no less frequently than once per year that what they're doing is actually achieving the value-based purposes that the arrangement is intended to achieve. And if it turns out that you're not achieving those value-based purposes, you actually need to terminate the arrangement. They give you a little bit of kind of like a probation period to fix the problem if you think you can fix the problem, but ultimately the arrangement needs to be terminated if you're not achieving the results that you want to achieve. We also see the reintroduction of the commercially reasonable concept here. So I mentioned a minute ago, fair market value, volume value of referrals don't apply under Stark or under anti-kickback. Commercially reasonable pops up in this arrangement, and there is a new definition of commercial reasonableness, which I'll talk about later. So we're going to be coming back to that in a second. The kickback statute, this is the one that only protects non-monetary remuneration. So this is, technology, for instance, can qualify. But one of the things that OIG points out is, again, you've got this predominant standard. And what that means is if you're receiving information technology tools, for instance, that have a value-based purpose, but could also be used for something that has nothing to do with these value-based arrangements, you need to be monitoring how that technology is used. So for instance, if it's software that you can use to track outcome measures, that would be permitted under the value-based safe harbor. But if the software can also be used by the entity to monitor financial metrics, collections, rate of return, for example, that's not protected under the value-based safe harbor. So OIG is basically saying you either need to disable that function or you need to figure out a way to separate payment for that function because it's something that they don't believe is protected under the value-based safe harbors. Parties have to have outcome measures under the kickback statute safe harbor that you're using, and there's some detail in terms of exactly what that means. Basically, what OIG is saying is that you need one or more benchmarks related to improving or maintaining improvements in coordination of care. The benchmarks and the outcome measures need to relate to the remuneration that you're receiving. And you can't set this up in a way where it's based only on patient satisfaction. That's not sufficient in OIG's point of view. I mentioned earlier that the recipient needs to pay 15% of the cost. That is of the remuneration. That's the OIG requirement under this safe harbor. The contract documenting the arrangement needs to explain how you got to those costs. That's another challenge. Or if you're not going to do that, then you need to use the fair market value of whatever the value of the technology is at issue to calculate the 15%. The remuneration can't be used for marketing activities. So you can use the technology to educate patients, for instance, if it's like iPads that patients can use in the waiting room and it can educate them about, chronic conditions or something, that could be protected. But if the technology can also be used to try to drive business, even if it's to drive business under the value-based arrangement, that doesn't qualify under the safe harbor here as well. And I mentioned earlier that a number of parties are excluded from participating. OIG actually creates an exception to that exclusion here for what they call limited technology participants. So if you're a device company, if you're a tech company and you sell products that are helpful for providers in monitoring outcomes, monitoring quality, making sure patients are really taking their medications, for example, there is a little bit of leeway for those parties to participate under this safe harbor that does not exist under the other two safe harbors. Stark law, not quite as restrictive, but certainly more restrictive than the other Stark exceptions. Stark doesn't require outcome measures, which is helpful. But if you're going to be using our outcome measures, there are some specific requirements that you need to meet. The payment methodology needs to be set in advance under this Stark exception. So that's the first time our set in advance requirement pops up in terms of financial payment. That doesn't exist under the other Stark exceptions, but it is relevant to this Stark exception. Now, the other thing OIG did, CMS did, is explain whether or not parties who use indirect compensation analysis under the Stark law can use the value-based exceptions. And this is an area where the changes have been pretty positive. I'm going to come back to indirect compensation a little bit later because there's really two important categories of changes. One is whether or not indirect arrangements can use these value-based exceptions, which they can. The other is how you define an indirect compensation arrangement, and that's changed in a helpful way as well, but I'll come back to that later. Essentially what CMS is saying here, though, is that you can use the value-based exceptions if you are in an indirect compensation arrangement. So a lot of the folks on the phone probably are nonprofit corporations, nonprofit entities. They don't have physician ownership. They're used to having employed providers, and they're used to analyzing financial relationships under the Stark law as potentially constituting indirect compensation arrangements. Basically, what CMS is saying here is that as long as either the physician or the entity to which the physician is an employee or contractor is a direct participant in a value-based arrangement, the value-based exceptions can be used to protect indirect compensation arrangements. The other thing CMS did is offer clarification on a little known exception called the risk sharing exception. And basically what's going on here is that back in 2004, CMS made some comments that suggested that if you have an arrangement that is downstream from any type of managed care organization, you might actually be able to use the risk sharing exception to protect financial relationships without having to deal with the volume or value of referrals requirement under the Stark law. And what CMS has done now is basically walk that back. And they're saying, no, that's not what we meant. The only way you can use the risk sharing exception is if the designated health services entity, so that's the party billing for DHS, is either a managed care organization or an IPA. So if we apply this to one example, you can see a little bit in terms of how it works. Our employed physician whose corporation has a services agreement with the hospital. So that employment arrangement could qualify for the value-based exceptions as long as we meet the requirements of that exception. So that's helpful. So with that, I'm going to hand it over to Tony, who is going to talk a bit about how we can do things to engage patients to participate in these arrangements.
Great, thanks, Jesse. So in keeping with the theme of promoting value-based care, OIG created a new safe harbor that protects arrangements for patient engagement tools. It's important to note that only patient engagement tools and supports furnished by a value-based enterprise participant receive protection. Jesse had talked about some of the entities that are ineligible, so pharmaceutical manufacturers, wholesalers, distributors, PBMs, laboratory companies, compounding pharmacies, and device manufacturers and wholesalers are ineligible for this safe harbor. Two notes on this. One, manufacturers of digital health technology that is intended to improve patient engagement are an exception to the exclusion for manufacturers in general. And two, OIG made a distinction between pharmacies that primarily engage in compounding and typical retail pharmacies that occasionally engage in such a practice. OIG believes there is a higher risk of fraud and abuse from compounding pharmacies and doesn't intend for retail and specialty pharmacies to be excluded. Another important condition of this safe harbor is that It only applies when it's furnished to a patient that's in a target patient population. That means an identified population selected by the value-based enterprise or its participants using legitimate and verifiable criteria that are set forth in writing in advance and further the value-based purpose. A number of commenters in the proposed rule and the final rule commented that that raises some challenges. For instance, with the ACO MSSP program, beneficiaries are assigned retrospectively. OIG acknowledged this issue and said that there's flexibility in defining the target population. A value-based enterprise can select the criteria without actually selecting the actual patient. So you can kind of select a demographic of patients and say this is our target patient population. Another requirement too is that the benefit needs to be furnished directly to the patient. And the significance of that is that OIG wants to prohibit ineligible entities from using another entity to furnish what they couldn't do directly. So as an example of that, let's say a pharmaceutical manufacturer can provide funds to a physician as a way to circumvent the restriction on manufacturers from participating. Okay, slide. Also, with respect to the safe harbor, there are limits on the type of remuneration that can be given. The in-kind requirement means that the patient has to receive the actual tool or support, and you can't just give the patient funds to purchase it themselves. But OIG does consider a voucher for a particular tool or support, so say like a meal voucher or a voucher for a taxi to satisfy the in-kind requirement. Gift cards were initially excluded in the proposed rule, but then OIG in the final rule decided not to specifically exclude those because in some instances, gift cards could be in-kind remuneration. Another requirement of the safe harbor is that it doesn't protect cost-sharing waivers. So it won't protect a physician office from waiving a copay of a beneficiary's that's a beneficiary's responsibility. And also with respect to this safe harbor that I think might be helpful is that OIG didn't introduce a specific definition of preventive care item or service. OIG wants the rule to be interpreted and be flexible. And but they did in some of the commentary state that electronic scales and tablets would be allowable under certain circumstances. Slide. This slide has the 5 goals and incentives and supports, and essentially what you're giving the patient or what whatever the support is needs to meet and advance one of these 5 goals. And I think generally, if something is directly related to patient care, it should meet one of these 5 goals. One example might be a smart pill bottle that dispenses medications at preset times. That tool allows a patient to take their medication at the appropriate dose and time. So that's going to advance and meet the requirement. Another could be a parking voucher or free childcare. Also, those are connected and allow a patient to comply with their treatment regimen. On the contrary, though, something that would not satisfy the requirement is if there's an offer to give a patient movie tickets to reward compliance for complying with the treatment regimen. Slide. Okay, this is a new safe harbor. This is the CMS sponsored safe harbor, and what this really does is it says that any CMS sponsored model that provides and allows remuneration to be exchanged between parties to the arrangement or to be provided to patients is going to be allowed from OIG's perspective. And this is a shift from OIG's prior approach where they would look at each model as it comes. What is also significant about this and what OIG's position is they place the responsibility on CMS to describe the type of activity that's allowed, the providers that can participate in the activity, and any other conditions. So it has to meet whatever CMS prescribes as the requirement. One thing to be careful about is that this safe harbor isn't intended to protect commercial and private models that might be based on the CMS model. So what comes to mind for me is the MSSP ACO program. Commercial ACOs won't get the same protection. Slide. Okay, so let's get into the cybersecurity and EHR exceptions and safe harbors. I added this slide. I think it has some good advice. Don't use a pet name as your password, and also avoid using your campaign slogan as a password as well. Slide. So the anti-kickback cybersecurity safe harbor. First, I just want to point out that the OIG considers fraud and abuse risks associated with the donation of cybersecurity technology to be similar to the risks that might be associated with provision of EHR technology. So the EHR safe harbor really laid the groundwork for the cybersecurity safe harbor. There are 5 conditions to meet the anti-kickback cybersecurity safe harbor. 1, the donation must be necessary and used predominantly to implement and maintain effective cybersecurity. So you can't give a full care management platform and have it fall under the safe harbor. 2, the donation must not take into account the volume or value of referrals or other business between the parties when determining eligibility or when determining the nature of the technology and services to be donated. So you can't just offer this to your high referral sources. So we'll see how that is interpreted. Another requirement is that no recipient can demand explicitly or implicitly a donation in return for doing business. OIG received several comments saying that providers were saying that they needed an EHR donation or something along those lines in order to refer cases. Another requirement is that there is a writing requirement, but it's not a contract requirement. So basically what the anti-kickback statute is saying here is that they need a collection of documents. And that's just something that generally describes the cybersecurity and whether there's a contribution requirement by the recipient. And finally, another requirement is that donors can't shift the cost of the donation to federal healthcare programs. So you can't include a donation in your cost report. The definition of technology is very broad, and the protected services includes the development, installation, training, actual services like for business continuity, data recovery, and also the risk analysis and vulnerability analysis or penetration test. Slide. This is the Stark cybersecurity technology exception, and it's very consistent with what OIG has as its safe harbor. You'll see that unlike the Stark EHR exception, there's no contribution requirement. So, but there's no prohibition on donors requiring contribution. There needs to be written documentation, very similar to the anti-kickback statute, which has a general description of the technology and services, the time frame of donations, a reasonable estimate of the value of the donation. They don't expect anybody to perform a study on what that value is going to be or anything like that. If there's any financial responsibility on the cost of the recipient, that needs to be included. And there is not a signature requirement. CMS wants to avoid inadvertent violations. So they specifically stated no signature requirement for this exception. Slide. Okay, now we'll talk about the anti-kickback statute, EHR, donation safe harbor. This is an existing safe harbor. It was scheduled to sunset, and the reason behind that is that OIG didn't think that this needed to be permanent. The thought was, when it was first proposed, is that when EHRs are adopted, every provider will have one, and then we can eliminate it. But OIG realizes now that technology changes, there are new entrants into the medical practice, and there's new and better technology. So they just got rid of the sunset provision. They had been moving it back, and this is now a permanent safe harbor. This safe harbor has a few more requirements and conditions than the cybersecurity safe harbor. But if you're donating an EHR and it contains cybersecurity technology, it can also fall under this safe harbor. You don't have to meet both of them. So, slide. The Stark EHR exception, very, very similar. It removes the sunset provision. Stark, there was a lot of discussion on the interoperability requirements and whether there was going to be a specific prohibition on information blocking. And CMS looked at all the comments. They considered the complexities of the information blocking, and they really agreed with the commenters that that's really a complex issue, and there are other regulations that address it and agencies that are better suited to handle that issue. And when I say information blocking, what I'm referring to is, say if there is an EHR donated, but I kind of configure it so that the recipient can only communicate with my EHR system and can't communicate with my competitors. That would be information blocking. In the rule, CMS considered removing their 15% cost sharing requirement for rural providers, and they considered removing that requirement altogether, but they decided to keep it. And I think I'll hand it off to Jesse. Thanks.
Thanks, Tony. So we also have seen a number of really important changes under the Stark law that I'm going to talk about now. In particular, the definitions of commercial reasonableness when compensation takes into account the volume or value of referrals or other business, and how we define fair market value. A lot of this comes from the fact that starting in about 2009, we've seen some very aggressive False Claims Act cases that have been pretty successful and have challenged a lot of common business practices in healthcare. And that has caused hospitals and physician groups in particular to reach out to CMS and to look for guidance around whether or not some of the common business practices that they have used truly are problematic under the Stark law and the False Claims Act. And CMS has done some things that I think overall are pretty positive here. Now, one of the things to remember, though, is that when CMS makes these changes, they're only making these changes for Stark law purposes. A theme in this rulemaking is lots of questions from the industry about whether the anti-kickback statute analysis can use similar guidance, for example, can rely on the same definitions of, for instance, when compensation might take into account the volume or value of referrals. And the answer there has been no. So this is the author of the law that we spend so much time thinking about, Pete Stark himself, back from 1989 when the Stark Law was first created. Here he is when he retired from Congress a few years ago. And the reason we have this slide here, it's really just a catalog of the important rulemakings that have been made under the Stark Law. And it's out there because one of the things folks have had to deal with for a long time is going back to preamble commentary to answer some of these questions. So for instance, what does it mean to have commercially reasonable arrangements? For instance, and I apologize that the top of the slide is blocked here. It has to do with the function of the software. But essentially what CMS has done now is they've gone back and they've said, look, we realize we've never formally defined commercial reasonableness. So we're going to do that here. And we've got a final definition in the middle of the slide there. It basically takes the two definitions that were proposed in the proposed rule and it combines them into this definition here. One of the helpful things it does is really is to sort of preempt one of the arguments that's been made in some of these False Claims Act cases I mentioned, and that is it possible to have a commercially reasonable arrangement if there's no profit? So if we're losing money on a contract between a hospital and a physician group, for example, how can that be commercially reasonable? And there have been enforcement actions and key TAM cases that have alleged that that would never be commercially reasonable. And one of the things CMS did here, in addition to defining commercial reasonableness, is to come out specifically and say in the regulations, yes, you can definitely have an arrangement that loses money and that can still be commercially reasonable. And they give lots of examples about how that might work. And they actually wrote this into the regulation, this concept of an arrangement that is not profitable as being commercially reasonable. And that's significant because one of the things that people have repeatedly asked CMS to do is, instead of requiring all of the people who deal with Stark to go back and look at these rulemakings and various comments in the preambles, can we put some of these concepts in the regulations themselves? And they've done that here with this question about profit motive. They didn't do it in a few other areas though, and we'll talk about that going forward. A few other comments that CMS made about commercial reasonableness. Not exactly news flash here, but one of the things they've come out and said specifically is that if you have multiple arrangements for the same set of services, they view that almost as a presumption of not being commercially reasonable. So be aware of that. Another significant change has to do with how we define whether or not compensation takes into account the volume or value of referrals. And this has been very challenging for organizations in the past due to the way the Stark Law historically looked at it. And what I mean by that is basically the way these regulations have historically worked is that CMS outlined in the rules the limited circumstances where compensation would not take into account the volume of value of referrals or other business generated. And of course, that left parties wondering, if you don't fit exactly in CMS's definition of when compensation does not take into account volume or value of referrals, does that mean that your compensation does take into account the volume or value of referrals? And that's been very, very challenging. We've seen a number of enforcement actions, the Halifax case, the Toomey case, for example. These cases have generally involved physicians doing work in a hospital setting where the hospital bills a facility charge every time a physician bills or performs a professional service. And CMS has made changes here to try and get in front of this issue. And basically what they're doing is they're flipping the presumption. And now what they're saying is, we're going to define the limited universe of circumstances where compensation will be deemed to take into account the volume or value of referrals. And basically what they've done is they've created 4 new standards that essentially mirror each other, and they look to the question of compensation going from an entity to a physician, so a hospital buying services from a physician group, for example. And then they've looked at compensation going from a physician to a hospital. So for instance, a physician leasing space or equipment from the hospital. And then they've applied under both of those tests a question of volume or value of referrals and other business generated. And the good news is that that sounds like a lot, but they've actually used essentially what is the same test for these requirements. And basically what they're looking at here is whether we have what they call a positive or negative correlation between the physician's referrals and the rate of compensation that is paid, is essentially the test that they're using. And really what they're trying to do here, they're trying to be as objective as they can. They're trying to make this almost a mathematical test to the extent that they can. And what they're saying is that if you have a positive correlation, that basically means referrals go up, compensation goes up. And a negative correlation basically means one variable goes up and the other one goes down. And we'll walk through some examples so you can see exactly what I'm talking about. And let's think about it in what's probably the most common situation, which is compensation from an entity to a physician. So I've outlined the test here. We're really thinking about whether the referrals are valued in the compensation terms and whether the payment rate positively correlates to those referrals to the entity. And if you sort of try and apply this to a fact pattern, you can see how it works a little bit. So we've got two potential payment options here in our arrangement between a hospital and a physician group. The first one, pretty common situation where the physician group is paid on a work RVU basis for professional services that they render. Second option, a little bit more aggressive. We're paid a percentage of collections from a pool. That pool includes collections from the services that we render and also from services that our physicians might refer to the hospital and that are billed by the hospital. So, designated health services in that situation. And if we apply the new volume or value test to these two alternatives, the first option, we do not have a volume or value problem anymore. And this is good news for physician groups working in the hospital setting. And the reason is because the physician's referrals are not a variable here. Personally performed services are not referrals under Stark. So our physician rendering professional services in the hospital, even though the hospital is billing a facility charge, we do not have a volume or value of referrals problem. And I'm going to come back to that in a little bit because CMS has said some more things on that specific topic. What about the second option? Well, in this situation, we do have a volume or value problem when we apply this formula. And the reason is, in CMS's eyes, the percentage of collections includes not only work that the physician did himself or herself, but also a percentage of collections from services that are referred to the hospital. So the more referrals, the greater the pool, the greater the percentage that goes back to the doctor. And that's how CMS wants the analysis to work. Now, if we flip that and we're talking about compensation paid by the physician to an entity, it's essentially the same test, but now we're looking at a negative correlation. So if referrals go up, does compensation go down is essentially what CMS is thinking about here. So you apply that test to a similar fact pattern where we've got a physician group leasing space from a hospital. Hospital says, you know what, we'll reduce that lease rate by $5 for every diagnostic test that you order. So that would be a negative correlation, right? Because the dollar amount that's paid, that's going down as the referrals go up. And that's how CMS wants us to look at that analysis. The second alternative here, which is basically where the hospital is saying, hey, tell you what, we'll reduce the lease rate if you are in the top half of admissions, or we'll increase the lease rate if you're in the bottom half of admissions. Well, this situation is a little different because in the proposed rule, CMS had an alternative definition for volume or value that would have prohibited that. they've actually changed things around a little bit, and they've moved this concept into a different part of the Stark regulations having to do with systems that are trying to mandate referrals. And basically what CMS is saying is that you can't condition the existence or the amount of payment on requiring referrals. So you wouldn't be able to use option 2 under Stark, but it's for a slightly different reason than it would be under the proposed rule. Okay, so this is the other volume or value concept I wanted to really highlight. This comes from the Toomey case, for instance, and it's this issue of rendering services in a hospital setting. And basically, enforcement agencies, Department of Justice, the key TAM plaintiffs bar, they've had a lot of success with these cases. They've also had success with, common arrangements around tracking referrals, monitoring referrals, and really whether those kinds of arrangements create a volume or value of referral problems under the Stark law. And what CMS has done here is they've come out and they said very specifically, you can pay a physician who's an employee, who's an independent contractor under a direct or under an indirect compensation arrangement, and you can pay that physician based on professional services in a hospital, and we will not have a volume or value problem, even though the hospital is billing for those designated health services that result from the physician's professional services. So that is helpful clarification. Now, folks did ask CMS to actually include that in the regulations the same way they did with commercial reasonableness, and CMS said no, they didn't want to write it into the regulation, which is kind of interesting, but that is where they are currently. The other thing I'll say on volume or value before we move off of that topic is it doesn't quite apply to every single Stark exception. The top of the slide here lists a number of exceptions that actually still have a volume or value standard, and they're not using the methodology that I just walked through. And the reason is that CMS believes these exceptions are unique and present different types of risks. Okay, so what about indirect compensation and volume or value? I mentioned this a little bit earlier. This is another helpful change because basically what CMS is doing now is they're recognizing that the way they have historically defined indirect compensation essentially sweeps too many arrangements within its scope and requires parties to meet the exception. And the arrangements at issue aren't really problematic as CMS sees it. So what they've basically done here is they've rewritten the second part of the test for defining when you have an indirect compensation arrangement, which focuses on the compensation that's paid by the physician's employer to the physician when there's a chain of financial relationships running from physician, employer, hospital. So for instance, if we're dealing with a nonprofit corporation that doesn't have physician owners. And basically what CMS is saying here is you're only going to have an indirect compensation arrangement in the following three situations. One, the compensation paid under the employment to the physician is not fair market value. Or 2 and 3, which are basically the same thing, saying you're including the physician's referrals to the hospital as a variable, and you've got this positive correlation between referrals and compensation in the same way I just talked through a minute ago. So if we apply that to a fact pattern, you can see what I mean. Options 1 and 2 here, we would not have an indirect compensation problem or arrangement anymore. So you wouldn't even need to worry about the exception as long as we've got fair market value compensation paid to our physician from the C3. Option 3, here we do have an indirect compensation arrangement for at least one reason, maybe 2 reasons. The first reason is because we've got this correlation again between referrals to the hospital and the hospital paying back a percentage of the profit back to the physician group. And then potentially the second reason we have an indirect compensation arrangement is I mentioned $120 was consistent with fair market value. Do we have a fair market value problem if $100 per work RVU plus 15% of the pool gets us outside of fair market value? So that would be the other step in the analysis. Some other changes that have been made here. CMS has kind of revamped how it regulates parties who require referrals to each other. And basically, I mentioned this already, but the fundamental change here is that what you're prohibited from doing is making the existence of the compensation arrangement or the amount of the compensation contingent on the number or value of referrals. You're not able to do that and rely on this test under the Stark Law. Now, what's interesting is if you do have a referral requirement in a payment arrangement, you can require a specific percentage of referrals. And so CMS is essentially saying they view that as being different than the number of referrals or the value of referrals. Fair market value, that's seen some changes as well. This actually looks like more than it is because really what CMS has done here is two things. One, they've tried to separate out the test of whether compensation is fair market value from the question of whether there's a volume or value problem. Basically, what they're saying is that those are separate tests, and they believe the way they have currently defined fair market value over the past 20 years or so has caused people to conflate the two concepts. So they're trying to pull the volume or value issue out. And then the other goal is to simplify the definition that they're using so that the guidelines for determining fair market value of rental property are treated separately. CMS did make a number of helpful observations in the commentary. Some of them have been reflective of the False Claims Act cases that I mentioned a minute ago. So for example, one of the things people asked CMS was, look, how about setting up a rebuttable presumption of fair market value? So if I'm within a specific percentile range, can we assume that's fair market value? And CMS said, no, they're not willing to do that. So you can read the definitions of fair market value and then general market value on this slide and then the following slide. The reason there's a strikeout here is because this concept of like parties and under like circumstances was something that CMS was considering in the proposed rule. They decided not to include it because, again, they're trying to separate out this volume or value concern from the fair market value concern. So you've got three different definitions of fair market value, depending on whether we're talking about general arrangements, equipment, or space, and then three different definitions of general market value that are tied to the type of transaction at issue. CMS made a number of other comments, and one that's particularly helpful is that one of the theories that's had some success in False Claims Act cases is if you're paying your physicians, for example, above the 75th percentile, can that be fair market value? And there's some authority that says you could never pay above the 75th percentile and be fair market value. And of course, that doesn't make any sense. But it, was an argument that had seemed to have some traction in some of these False Claims Act cases. And CMS has basically come out and said, look, just because you're above a specific percentile, that doesn't necessarily mean you've got a fair market value problem. What they want folks to do is be able to document fair market value in the context of the subject transaction. And they've given some examples in the rulemaking about how that might work. For example, when you have a type of physician who should be paid $450,000 based on survey data for that physician's productivity and the reasons why it would make sense and be consistent with regulatory guidelines to pay that physician more than $450,000. So that's helpful clarification as well. A number of changes to the definition of group practice that I'm actually going to not talk about in the interest of time, other than to say that these have been delayed till January 1, 2022. So everything else we're talking about is in effect as of January 1, 2021. These changes, which are intended to help group practices participate in value-based arrangements, and then also to have more clarity around how you can allocate profits from designated health services within a group practice, those are delayed. Now, I will say if you are a group practice and you're dividing up your physicians using the rule of 5, and if you are, you'll know what I mean by that, you should pay attention to this because CMS is offering some new explanation around when and how you can allocate DHS revenue and when you can't allocate DHS revenue. But again, this is being held off for a year. Like Gwyneth and Chris Martin, we've seen a decoupling, a conscious decoupling of the Stark Law and anti-kickback statute. And this is this is a helpful change because one thing that folks have objected to under the Stark Law is the requirement that exists under many of these exceptions that parties not violate the anti-kickback statute as a condition of complying with the Stark Law. And that's challenging to prove because the anti-kickback statute is an intent-based law, and parties have struggled with that. So CMS has heard those complaints, and they've removed that element from most of the exceptions other than the fair market value exception. It's still included in the fair market value exception. Another thing that's helpful is to create a bit of a grace period for parties that sign up new arrangements but forget to document them in writing or get them signed. You now have up to 90 consecutive days to make that happen. And this guidance should be helpful. It's intended to get in front of some of the disclosures, the self-referral disclosure protocols that CMS has had to address over the past few years. CMS has made some changes to the set in advance rule that now permit you to modify compensation terms in the middle of an agreement as long as you do so in specific circumstances. So this is another helpful change. And then they've made a helpful change to the definition of designated health services if you're an inpatient, if you're a hospital that bills for inpatient hospital services under any of these prospective payment systems on the slide here. And basically what they're saying is we're going to change the current rule so that if a physician refers for inpatient hospital services, that's only going to be designated health services if it affects the payment rate under the PPS. And the reason they're making this change is that these payment rates are set based on patient diagnoses in advance of most referrals for a MRI or an X-ray after a patient has been admitted to the hospital, for example. So CMS is trying to limit situations in which hospitals have a Stark Law problem in the event our physicians make referrals while patients have been admitted. And with that, I'm going to turn it back over to Tony to talk about some more Stark Law changes.
Great, thanks, Jesse. We've still got quite a few slides left, so I'm going to just kind of go through these pretty quick. This slide just deals with the change, or actually just some comments on the definition of referral. CMS just wanted to clarify, and it said that it thinks that it's pretty obvious that a referral in and of itself can't be characterized as an item or service so as to fall into a Stark exception. So if I own a hospital, I can't contract with a physician to provide me referrals and structure that contract to fall into the personal services exception. So that cannot be done. Slide. Next definition is remuneration. This is really just a very nuanced change, and basically the issue is that under the definition of remuneration, there's an exclusion for certain items. CMS just kind of changed the rule a little bit as to how that test is determined to see if there's an exclusion. The slide kind of covers it, but I think it's going to only affect a very small portion of providers. So let's go ahead and skip this slide. Isolated financial transactions. So CMS made a change to this definition because it saw that people were misunderstanding how it's supposed to be used through the self-referral disclosure process. And a lot of these changes are made from based on that CMS's experience with the self-referral disclosure process, and CMS getting way too many disclosures, much more than anticipated. I believe that sometimes there was a several-year backlog for CMS to process those disclosures. So I think that we're seeing a lot of that here. But with respect to the exception, what CMS intends is that, or actually what people were misunderstanding is that they thought this exception could be applied when there's a single payment for services that took place over an extended period of time. And generally what would happen is that parties would see that that they had an issue, that they didn't have the documentation to meet one of the other exceptions. Then they'd make a single payment to try and square all the parties. and then they would try to characterize that payment as an isolated transaction. And CMS just commented in the rule that if Congress intended to allow individuals to correct non-compliance with very specific requirements for certain arrangements by entering into this exception and allow this exception to apply, that would be nonsensical. So CMS took that position on with respect to this exception. Slide. The period of disallowance. This is a really important change here. This refers to the period of time during which a compensation arrangement is out of compliance with a Stark requirement. That means during this time, a physician may not make referrals to DHS. And that's really an issue when you're doing a self-disclosure, figuring out what that period of disallowance is. The rules were meant to provide certainty. However, CMS took a look at it, and especially after all the self-referral disclosure review, and said, okay, these rules are overly prescriptive and impractical. And CMS said parties shouldn't consider this rule as the only way to establish the period of disallowance. CMS said that so they basically deleted the rule or deleted the provision that provided for that. CMS did say that you can still use that test if you want, but really the general rule is that the period of disallowance begins on the date that the financial relationship fails to satisfy all the requirements of an exception, and ends on the date that the financial relationship ends or satisfies all requirements of an exception. Slide. So this kind of led to another issue that is very interesting, is that can you correct the issue and completely avoid the period of disallowance? And CMS had talked about this before in some prior rulemaking, but I think they were more clear in this rulemaking than they have been in the past. And CMS said the compliance program is intended to discover errors. If the compliance program discovers an administrative error prior to that relationship ending and it's rectified, then there's no period of disallowance, which it's a really good thing for providers to be able to avoid a violation. However, then you kind of extend that issue, and then providers are saying, well, what if the issue is corrected 3 days after the relationship ends? Where do you draw that line? And CMS said they kind of took a hard stance on that. Providers were saying, what if we use a good faith effort to collect the money? What if we file a lawsuit? And what CMS said is, no, it needs to be rectified. However, all of that action, so the good faith effort to collect, filing the lawsuit, that's going to be relevant for determining when the period of disallowance stops. So my interpretation is that you've lost the opportunity to rectify the situation, but you can at least make sure you put a stop date to the period of disallowance. Slide. Okay, this is another exception, the limited remuneration to a physician, and it's intended to cover those really small issues. And actually, this is a big one. Hopefully, this is, I think CMS wants to reduce those disclosures and avoid situations where there hasn't been an abusive practice. This really should be very significant. This allows up to $5,000 to be provided to a physician, but in exchange for services or items. The payment can exceed fair market value, and the payment needs to be commercially reasonable, even if there are no referrals. So in the final rule, they also said that if there is a referral requirement to the relationship, it needs to meet the requirements of 411, 354 D4. So basically signed by the parties, set out in writing in advance, compensation arrangement type requirements. Slide. This is the ownership or investment interest. Won't spend much time here. Basically, CMS extended this kind of an exception where it didn't consider titular ownership to be an ownership or investment interest. So it used to only apply to compensation arrangements. Now they also have that exclusion and recognize that exclusion for ownership or investment interests. CMS also said that employee stock ownership programs will not be considered an ownership or investment interest for stock purposes. Thanks. Slide. Rental of office space or equipment. This is a pretty significant one. The exclusive use rule under the rental of office space or equipment exception. Individuals were submitting self-disclosures if they were sharing space with another provider, and they interpreted the exception to not allow that. And CMS said, well, that's not what we intend. What we're really concerned about is sham leases between the lessee and the lessor. An example of that would be the lessee leases space from the lessor, they share that space, the lessee isn't really using the space. And really that's just a way to provide compensation to the lessor. CMS is really concerned about that. So the exclusive use requirement does apply as between the lessor and the lessee, but not between the lessee and other parties that are unrelated to the lessor. I think that's a helpful clarification. Also relevant with respect to rental of office space or equipment, the fair market value exception can now be used there. So it could not be used in the past for office space or equipment, but now it can. The significance of that is that that exception does not require a one-year term like the office space and equipment exception. Slide. So this slide talks about remuneration unrelated to provision of DHS. CMS actually didn't change this. They considered broadening it, but then they thought it would be too challenging because individuals would sort of find ways to expand it. So they decided to leave it as it is. A slide. Payments by a physician. This is another expansion where basically the payments by a physician that was precluded against individuals couldn't use that exception if there was another exception that was more directly on point. CMS took a look at that and said, well, if it's a statutory exception, then that needs to apply. But if it's a regulatory exception, we will allow you to use this exception. And the reason is because this is actually less onerous than some of the other exceptions. But the recruitment exception, this one is actually pretty nuanced and probably won't have much of an effect on a lot of our audience. So let's go ahead and skip that one. Okay, anti-kickback statute. So it looks like we've got about 3 minutes left. Maybe if we just want to kind of skip to the end. Basically, just to summarize the changes to the anti-kickback statute, it's intended to make things more flexible, be easier to apply. The personal services and management contract safe harbor, that's an important one. It's going to allow a lot more relationships to fit into that safe harbor, specifically because it eliminates the requirement that the aggregate payment be set out in advance. That's a very difficult standard to meet. Now they eliminated that and just said the methodology needs to be set out in advance. So that I would say is probably the most significant change to the anti-kickback statute safe harbor. Slide. 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 Okay. Yeah. Why don't we just go ahead and skip to the end? Almost 1:30. Final thoughts. I thought Jess did a really good job of pointing out the themes of value-based care taking over. And I just really look at this as CMS and OIG. They want to eliminate some of the paperwork and provide avenues for providers and others to sort of figure out how they can use these exclusions and apply them to the relationships that they have. Jesse, do you have anything to add?
That is terrific, Tony. So we do have a number of questions, and we will try and just tackle a couple with respecting everybody's time. So one question had to do with how you define the definition of full financial risk under the exception and safe harbor. I mentioned at the beginning, Stark Law and Kickback each have one. And so that is a little bit different under each. Basically, the definition under the Stark Law is that the parties have to be financially responsible on a prospective basis for the cost of all of the patient care items and services that are covered by the payer. So that illustrates the fact that you really need to have payer involvement in these arrangements. And what that actually means is the payer either has to be part of the value-based enterprise, or there needs to be an agreement with the payer in terms of defining that standard for purposes of Stark Law and for the anti-kickback statute. Another question, and I will, I think, say that this is the last question that we can answer is whether or not you can provide cash to patients under the value-based exceptions, and so have the patients as a participant. Okay, and so that's a good question. So technically, the exceptions and safe harbors that Tony talked about around patient engagement, that's really the only way anything involving the patients can be protected. You can't actually keep the patient, you can't actually have the patients qualify as participants under the value-based exceptions or safe harbors. You can provide things to the patients as Tony walked through, but you can't include the patients as essentially parties to the value-based arrangement and use the remuneration between the providers to pay the remuneration back to the patients and qualify for that exception or safe harbor. Basically, the patients aren't allowed to participate, but that's a terrific question, so thank you for asking that. And with that, we are at time. We really appreciate your attention today. I realize there are more questions, so feel free to email either Tony or myself or both of us, and we'll do our best to respond to you. Thank you for your attention. And as I mentioned, we'll be sending out some follow-up materials around this event. So thanks, everyone. Have a terrific rest of your day.